Hello, and welcome to episode 5 of The Legal Scoop, our web series where we discuss recent wins here at LOMAD. Today I'm joined by Melanie Daly.
Good morning, everybody.
Who's going to talk about two notable wins that she had recently. So I understand that your first major win was a disallowance for a neck claim.
Correct.
So why don't you tell me a little bit about some of the basic facts?
Okay, so this was a claim for a shoulder injury. It was accepted and established for the shoulder. And then the claimant had been treating for the shoulder, and he did not mention any complaints of the cervical spine for several months into treatment. He then raised the neck as an issue, and we raised all issues controverting it. We reviewed the medical records, and in the beginning of the file, he was treating for the shoulder, and during each medical visit, not only with the treating provider, but with the physical therapist, they were conducting physical examinations of the cervical spine. And they were noting in the reports that it was a normal examination, no pain on range of motion, full range of motion. So there was indication that, his cervical spine was in fact being looked at and actually examined. So then he raised the cervical spine like 5 months after the date of accident.
Okay, so it was being raised as an additional site?
Correct.
Okay, so did we get an IME?
We did not get an IME. We figured based on the medical and the reported examinations and the fact that he presented to a brand new doctor after 5 months to get that PFME for the cervical spine, we had enough basis to deny the claim, get the claim disallowed based on the claimant's treating provider's opinions.
Okay, so it sounds like there's a few things going on here. So for those of you who don't know, causal relationships, the burden of the claimant, and the claimant's got to produce medical evidence that supports a claim for any site that they're raising. We have no obligation to produce an IME that's providing contrary evidence.
Correct.
So that's why you recommended no IME there.
Yep.
So the other thing it sounds like is going on is that this new doctor didn't review medical records
Yes.
that are relevant to the claim for the cervical spine, right?
Correct. The first doctor that he was treating with for the shoulder did not mention any pain in the cervical spine despite those examinations for at least 4 to 5 months. Then the new doctor that did see the claimant reported in his report that the claimant's pain in the cervical spine started at the onset of the claim. So it was essentially contradicting the original doctor's opinion. And we did actually take the deposition of the first doctor, and he testified that the claimant had no complaints of pain for the 5 months. So essentially it was contrary to the PFME doctor.
Oh, wow. Okay, so it sounds a lot like a Fox situation.
Correct.
So there's a third department case from I think 2 years ago, Fox v. Altmar Parish. I don't have the site in front of me. It basically said if a doctor doesn't review prior medicals or pretty much anything else that might be relevant to an opinion on causal relationship, that their opinion's invalid, and it's been repeatedly reaffirmed at the third department, most recently in Yearwood, which was from 2022. It's a very useful case law to cite in situations like this where, really to no fault of this doctor,
Right.
he wasn't made aware of records that might have changed his causal relationship opinion. It sounds like that's part of how you prevailed.
Yeah, he was essentially relying on the history provided by the claimant, which was contradicted by the earlier medical reports that doctor didn't review.
Perfect. So, I feel like I've kind of buried the lead a little bit, but what was the result?
The result was a disallowance, and funny enough, the crux of the argument of the claimant's attorney was that we did not get an IME, and that therefore there was no contrary medical to state our position. However, we argued that we don't need contrary medical. The burden is on the claimant.
Right. And would you agree that's a pretty common tactic?
Common,
right?
yeah.
Yeah. And at LOMAD, we're very good at reminding judges that that's not our burden.
Yes.
So,
and we did so, and she agreed.
So I want to move on to the next case that you won, which, it's my understanding, involves latches, which is something we'll have to explain for everyone.
Yes.
Why don't you tell me about the facts?
So this is an older claim. It was a knee injury. The claimant had received a loss of use many years ago. Then she did have a total knee replacement that was approved causally related in 2014. So then in 2021, she filed for a hearing to get awards for that time in 2014 during the
Wow.
time of her surgery. So she was requesting awards at a total disability in 2014 at the
7
time of her
years
surgery.
later.
Yep, 7 years later. So essentially, we requested her testimony on whether or not she had been working prior to the surgery. If she was not attached to the labor market and already not working, even if there is an opinion of total disability, which resulted from the surgery, she's still not entitled to awards.
Right.
So we wanted to get her testimony, and essentially all of the medical reports leading up to the surgery indicated that she was not working at that time. But
Okay.
she testified that she was, and she stopped working as a result of the surgery.
Okay. Now, there's obviously a substantial delay here.
Yes.
You raise latches, right?
Correct.
So, for those of you who don't know, latches is sort of a fancy legal term for when we raise basically the issue of an unnecessary delay.
Correct. Inexcusable delay in raising awards.
Right. And pretty much the elements that you need to establish when you're making that argument, and it does apply in comp, there's lots of case law supporting this, is that someone had a legal right that they didn't raise for a long period of time. That's sort of fact specific.
Yep.
And that it prejudiced the other party, which in this case would be us.
Correct. Because we were not able to defend the file and raise voluntary removal or determine her work at that time in 2014. It wasn't until she raised it in 2021, and there was no documentation we could request regarding her cease of employment, and there was really no fair way to defend the file 7 years later.
And you couldn't get an IME 7 years ago on degree of disability
Correct.
to assess her claim for awards.
Yeah.
So I'm assuming that's sort of where the judge came down on the issue.
Well, actually, the judge awarded the awards.
Oh, really?
So then we appealed, and the board came down and said, agreed with us, so they rescinded the awards based on latches.
Wow.
Yeah.
So, yeah, latches is a unique argument, but it's one to always keep an eye out for.
Yes.
Because you do see this happen fairly often. I think a lot of adjusters watching this could attest to having claims sort of zombie files.
Yes,
come out
zombie
of nowhere.
files. Yes.
So that sounds like a really great win. That's 2 great wins.
Yes,
in your
2
belt.
great wins in the same week.
Yeah, wow. So congratulations.
Thank you.
That wraps up today's episode of The Legal Scoop. Join us next month for hopefully more wins here at
Yes.
LOMAD.
Thank you, everyone.